Master of Law and the Secretary of State for the Home Department.
Yes, Mr. Raza, thank you for the updated skeleton arguments which we've received from each of you. They're very helpful. Just by way of introduction, although this case had a rather different focus for a very long time, it seems that we're now in quite a narrow area. And I think it might be helpful to everyone, Mr. Raza, if you kindly begin by just spelling out precisely what matters you say you are entitled to appeal against. Lady Justice Andrews limited the permission to appeal. Reading the skeleton, there may be a concern as to whether some of the points made in the skeleton stray outside that. So should we begin by you just setting out your stall, if you would, please?
Thank you very much. The panel is correct. There were two central strands to the appeal before the upper tribunal. The first strand concerned the appellant's ETS English language test and an allegation of deception, an allegation that that document was fraudulently acquired. The second strand was in respect of the approach to Article 8 of the ECHR in the event that it was found the document was fraudulent. The grounds of appeal, as well as the skeleton argument, do not challenge the upper tribunal's findings in respect of the allegation of fraud. And the challenge was limited to the upper tribunal's assessment of Article 8, both inside initially and outside of the rules. Lady Justice Andrews, in granting permission, as the bench quite correctly refers to, refuses to grant permission on any ground relevant to the appellant's ability to meet the immigration rules under Appendix FM, and grants permission solely on an evaluation outside of the rules under Article 8, and the upper tribunal's assessment and treatment of the proportionality assessment outside of the rules under Article 8. That is the limitation which appears in terms of the issues before this court. Having said that, what Lady Justice Andrews does also acknowledge is that some of the features relevant to the rules may also be relevant to Article 8 outside of the rules.
And that's consistent with observations made somewhere that if a decision maker or whatever has complied with the correct approach within the rules,
yes,
in order to conclude that it's outside the rules, then most if not all of the considerations that apply outside the rules will already have been considered. Is that a fair summary of the position?
That is. The only authority perhaps that I would be referring to in the course of my submissions which clarifies the approach outside of the rules is with respect to GM Sri Lanka. And in particular, one of the central points to the argument is there is, in my respectful submission, no proportionality assessment conducted at all by the upper tribunal judge, and no consideration of the factors in section 117B. The reason why that's important is because one of the material factors is in my respectful submission, first of all, the materiality of the ETS allegation itself to the initial grant of leave being awarded to the appellant, notwithstanding the fact that I still accept, of course, the allegation of deception prevents her from meeting the rules. But the materiality of it to the initial grant of leave, I say, is a relevant factor, which of course wasn't considered or under the immigration rules itself. And secondly, as well as the passage of time since the deception occurred, in my respectful submission, those aren't matters which are considered under the immigration rules.
Right. Thank you. Well, having in that way comprehensively steered you away from whatever you were planning to begin with, but please now proceed in whatever order you find most convenient.
I'm very grateful to the bench. If I may, perhaps first just briefly set out the additional documents I'd handed up this morning. Copies have been handed to those to my learned friend.
Yes.
At this stage, all I seek to do is inform the court of what they are, and I will be addressing their relevance in the course of my submissions. The first document is a document titled Appendix F.
Yes.
Those are the Secretary of State's GSID notes at the time of the appellant's application for leave to remain as a spouse.
Is that the initial application or the application which led to the successful grant?
Which led to the grant of leave, the application made on the 7th of December 2012, Judge. Yes. There is, the material part of it refers to the English language requirement, which I will be coming on to address in any event. The second document, in the first page of it, is a letter from ATM Law, which encloses the UK NARIC certificate referred to in the GSID notes. And the third document is the current and up-to-date caseworking guidance on ETS, the respondent's guidance on that. With that said, if I may perhaps begin by summarising the relevant background and history to this appeal.
Yes, I think you can take this quite briefly because we've read all the papers and we're familiar, but do by all means pick out features of it which you wish to.
I'm very grateful. The first point in respect of the appellant's own immigration history, I've summarised this at paragraph 3 of the skeleton argument. She was, for material purposes, first enters the UK in 2006, departs in time. She's then granted entry clearance as a working holiday maker from the 3rd of September 2008 until the 3rd of September 2010. Again, the appellant departs in time. She then makes an application for entry clearance on the 5th of April 2011, granting her leave to remain on the 8th of December 2012. The appellant's husband's immigration history is also referred to in depth in the explanatory note which accompanied or came at a later date after the 2015 decision. Again, a document I will be coming back to at a later stage.
What is his nationality?
He's a British national.
Does he have Indian citizenship as well?
This is not a matter in the evidence, but a matter I'm aware of. Indian law does not permit dual citizenship, so to acquire British nationality, you have to.
It does in certain circumstances. Limited circumstances, doesn't it? And I don't profess to be an expert, but I thought the position was that there are circumstances in which people, Indian citizens who've migrated abroad, retain a status which enables them to be there whenever they like. But
it was my fault for asking, if I may, an imprecise question. I should have asked what was the evidence before the court below as to the citizenship.
The evidence, I know there was the British passport, which was.
Was there any evidence about whether or not he has Indian?
So the only other point referred to is the witness's own evidence that he's a British citizenship. He's a British citizen.
He just says, "I'm a British citizen."
Indeed.
All right.
Ms. Pottle, we don't need to pursue that further, do we?
No.
Thank you.
I'm grateful. The marriage takes place on the 27th of June 2010. That is at a time when the appellant is lawfully resident in the UK, and by which time the appellant's husband has acquired ILR, having resided in the United Kingdom for 14 years unlawfully under the old long residence rules. The application for leave to remain is an application made on the 7th of December 2012, and that's an application for leave to remain as a spouse. And that application is granted by the respondent, granting the appellant leave to remain under Appendix FM, valid until the 20th of September 2015. At this stage, if I may, refer the bench to the GSID notes. These are the notes of the respondent which accompany the decision making at that time in respect of that spouse application.
This is Appendix F.
Appendix F, indeed. Turning to the second page after the screenshot of the computer, the first point is you see the date of application, 7th of December 2012, an in-time application. And if we turn over the page, this is roughly halfway down the page. It appears as slightly highlighted, and the first line reads, applicant meets the English language requirement, ELTRP 0.4.1, has TOEIC certificate with a total score of 550, and a NARIC letter to confirm language proficiency. That NARIC letter...
Do we have ELTRP 4.1?
Yes, and I'll take you to that.
Thank you.
Thank you, I'm grateful. First of all, that NARIC letter is the document which comes behind the covering letter from ATM Law. And what you see from that is it's found that the appellant's degree from Punjab University is equivalent to CEFR A1, level A1 of the CEFR. And to just address the Lordship's point in respect of what the rules required at that point, in the authorities bundle at page 21, my Lordships will find the relevant passage under Appendix FM relating to the English language requirement, and we'll see at subsections B and C, the required level is...
Did I mishear the page? What page number are you on?
21 of the authorities bundle.
Yeah, I did.
I think it starts at the bottom of 20, doesn't it?
Forgive me, my Lordship is correct. The passage English language requirement starts at the bottom of 20.
Thank you.
But the key part's on 21.
Indeed, I'm grateful. And what that confirms is the required level is CEFR, is A1 of the CEFR, and also that a NARIC certificate is sufficient for those purposes. Now, I accept, of course, at this stage that the appellant did also submit the ETS test certificate, which has been found to be fraudulent. But the simple point for the purpose of the present submission is the Secretary of State did have before her alternative evidence when making a decision on the application, which also satisfied that element of the requirement of the immigration rules.
I'm sorry to be so slow. What you rely on is subparagraph C, is it? On page 22, 21?
Subparagraphs B and C.
B and C.
Indeed.
Thank you.
So there are 2 points which flow from that. Of course, whilst I accept the ETS test was also submitted, but purely in the context of meeting the English language requirement, the appellant would have done so by submission of the UK NARIC certificate, which was before the Secretary of State at the time the application was made.
So why did you get the other one? Not in your brief. Precisely.
Yes. But the submission with respect is it wasn't material at that time the application was made. What then follows, my Lordships, is the decision to cancel the appellant's existing leave to remain on the allegation of ETS TOEIC fraud. And I'm sure the panel is familiar with the history, at least in respect of how these issues arose and the development of authority since 2014 when the issue first arose. The point is, upon return to the United Kingdom, a decision was made on the 18th of February 2015 under paragraph 321A of the immigration rules to cancel the appellant's existing leave to remain. And if I could invite the bench to turn to page 150 of the core bundle. That is the decision. The decision is purely predicated on the ETS deception issue, and the decision attracts an in-country right of appeal. The appellant lodges...
Sorry, I'm just struggling to find this document at the moment. The bundles aren't, I'd say, entirely satisfactory. So page 150 of the core bundle is this?
I'm so sorry if I may. It begins at page 148. 148.
Right. I don't know why I'm not finding that in the electronic copy, but never mind. Right.
That is the cancellation decision. That decision had the effect of cancelling the appellant's existing leave to remain as a spouse, and it's predicated singularly on the ETS deception issue, and the decision attracts an in-country right of appeal. The appellant lodges a right of appeal to the First State Tribunal, and as part of her grounds, she relies on Article 8 of the ECHR, i.e. that a removal would be disproportionate. And in response to that, you will find, beginning at page 140 of the core bundle, the explanatory statement which was filed in support of the FTT hearing, addressing the Article 8 issues. Paragraph 24 perhaps is the most pertinent. Confirming that the purpose of this document is to address the ground of appeal under Article 8, because of course the earlier cancellation decision did not do so.
Please forgive me, what was the paragraph number again?
24.
Thank you.
And that's page 146 of the core bundle.
Yes. Sorry, thank you.
And just to summarise here, in broad terms, the approach taken in respect of Article 8 by the respondent in this document is that the effect of the ETS deception issue is that the appellant cannot meet the suitability requirements under Appendix FM. It goes on to then consider EX.1 of the immigration rules, the insurmountable obstacles test. Although I do accept at this stage that perhaps is the false approach, because if you can't meet the suitability requirements, EX.1 isn't engaged, but that was the approach taken by the Secretary of State. And then going on to find that...
It's beneficial to your client, isn't it? Isn't it?
Yes.
There's another opportunity for you to
Yes.
make your way through.
Yes, but in terms of what I do accept is under Appendix FM, if you don't meet the suitability requirements, EX.1 isn't engaged. The only way any sort of argument under insurmountable obstacles comes in is outside of the rules in the context of proportionality. And it's in this context that the appeal comes before the FTT. There is then a rather more lengthy history in respect of the setting aside of the earlier 2015 decision. That was set aside de novo, and you have before you Upper Tribunal Jackson's error of law decision of 2020, confirming that the basis of that being set aside was a failure to conduct a proportionality assessment. That decision appears at page 61 of the core bundle. and concludes at page 64
And this sets aside Judge Jones
in its entirety, absolutely.
in its entirety, which we've got Judge Jones at page 113.
Indeed.
Okay, thank you.
Paragraphs 8 and 9 of Judge Jackson's decision is the elements which address the criticisms of the articulated evaluation, ultimately finding that there was no adequate proportionality assessment conducted. And this, of course, again, was also in the context of where there was a negative finding on the ETS issue in 2015. There is then a further adjournment to allow for the upper tribunal's deliberation of the reported case of DK and RK, which focused on the qualitative approach to be taken in respect of ETS cases. And it's that which then brings us to Upper Tribunal Judge Gleeson's decision, which is the subject of this appeal, beginning at page 29 of the core bundle. Now, as indicated, there is a single ground of appeal which refers solely to the Upper Tribunal's assessment and evaluation of proportionality outside of the rules. And the first point to make, the bench will note that the Upper Tribunal's analysis begins from paragraph 67, dealing firstly with the ETS element, and the Upper Tribunal's approach to articulate outside of the rules is, in my respectful submission, confined to the two concluding paragraphs of the judgment, those being paragraphs 73 and 74. Upper Tribunal Judge Gleeson begins by reminding himself that the rules aren't met. And in terms of his evaluation...
I think herself. I think
Judge Gleeson's.
My apologies.
Judge Gleeson is female.
I'm grateful. My apologies. And in terms of evaluation, Upper Tribunal Judge Gleeson rejects or finds there is no evidence of the family disapproval, finds there was a discrepancy in respect of an element of the evidence, where the appellant's husband had referred to a visit in 2014 to see friends, and the appellant herself referring to a visit in 2015 to visit her mother.
Forgive me for interrupting you. I'm right in thinking, aren't I, that once you're outside the rules, the burden, at least the evidential burden, is on your client to demonstrate.
The appellant would have to demonstrate that Article 8 is engaged in the first instance,
Because
which
you're
it is.
seeking the exercise of a discretion in your favour, and therefore you have to, at least as an evidential matter, raise the issue.
I would accept that any matter that the appellant seeks to rely upon in respect of Article 8 outside of the rules, or evidential matters relating to difficulties with going back to India or anything of that nature, the burden would be on the appellant to evidence that.
Yeah.
So that's the extent of what paragraph 73 says, referring to those two matters. And then turning over the page to paragraph 74, finding correctly that the appellant is no longer at the present stage receiving IVF, finding there are no significant obstacles to her integration in India, which is perhaps more so relevant for private life, for a private life claim which wasn't pursued in any event. And then finding and concluding there are not any insurmountable obstacles to this couple living together in India. And with respect, that is the entirety of Upper Tribunal Judge Gleeson's assessment of Article 8 outside of the rules. And the primary submission I do make at this stage is that is simply insufficient. And with respect, another broader point here is there is no balancing exercise. There is no weight attached to any positive factors in the appellant's favour, including their relationship, the length of time it's been together, nor any further evaluation, and there is no reference to the factors in section 117B, which are mandatory to consider. So that is the primary, if I could put it this way, headline submission, that analysis is insufficient because it doesn't amount to a balancing exercise or a proper or thorough proportionality assessment. If, having said that, I may now refer within the authorities bundle.
Well, just before you move on, Mr. Rasa, just looking at paragraph 74, to which you've just drawn our attention, nor indeed are there any insurmountable obstacles to this couple living together in India, of which they are both citizens. What was the evidence about that, in particular about the appellant's husband?
There was no evidence that he was an Indian citizen at the material time. Although the only evidence which was before the upper tribunal was at the material time he was a British citizen.
Thank you. Yes, sorry, you're about to move on.
I'm grateful. And to perhaps fortify why I say this is an error and a material error, the authority that I seek to place most emphasis on is GM Sri Lanka, which begins at 221 of the authorities bundle. And in particular, if I could invite the bench to turn to page 228, and in particular paragraphs 27 to 32.
Would you like us to read that?
I'm happy to summarise if the bench.
Well, perhaps it's best if we just quickly read it to ourselves, Mr. Ross.
Yes,
Thank
yes.
you. 27 to 32.
Yes.
Yes.
I'm grateful. In particular, paragraph 32 reminds us that there is a broad approach to be taken to proportionality outside of the rules. And we are looking at a proportionality test, i.e. where the fair balance lies. And in my respectful submission, paragraphs 73 and 74 simply do not accord with what is required, and it's not consistent with the character of evaluation required under Article 8.
Are you going to take us to the evidence that was before Tribunal?
Yes, and with that, so in terms of the evidence, I think I can summarise it rather briefly. The evidence, by and large, was both of the appellant's length of residence in the United Kingdom. 1995 since.
Could we see it? The evidence.
Yes. So. what you have beginning from 1, 2, 3 of the core bundle are the relevant witness statements from both the appellant and her partner and her husband. Forgive me. I accept at this stage, just to ensure the bench is not searching for anything else in terms of other documentary evidence establishing insurmountable obstacles. There wasn't any. It's the evidence in the context of their length of residence.
Which paragraphs in the statement do you say contain the evidence, comply with the fifth, the requirement for proper evidence as identified in the Sri Lankan case? Paragraph 9.
I'm at page 126
Right.
of the bundle. This is the second statement.
So,
Paragraphs 4 and 5 refer to the closeness of the relationship. And before that, the length of time from which the relationship has subsisted. Again, a matter which is not in dispute. And
sorry, I was looking at 4, 5, 6, what should be. And where did you go after that?
so 4 and 5,
Yes.
Lordship, on page 126.
Mm-hmm.
And then there are similar statements for the appellant's husband. Page 134, paragraph 8, where again he refers to the closeness of the relationship and his own mental health. Again, I accept there was no documentary evidence of that before the FTT. Before the upper tribunal.
So there's,
What of his ulcerative colitis?
Correct.
Okay.
so it's the second half of paragraph 8 as is on the top of page 135.
Yes. Yes.
And you rely on paragraph 9?
Paragraph 7 above that first, if I may, which is his income, purchase of his property in the
Yes.
UK.
7, 8, 9.
Yes. And paragraph 9.
He doesn't say anything here about his nationality.
He does at the beginning, just at the beginning. He says, "I'm an Indian citizen,
British.
I'm a British national.
British national,
Yes,
and we have his passport."
Again, forgive me, I was being imprecise. He doesn't say anything about his citizenship in paragraph 9.
About not being an Indian citizen.
Yes. He doesn't say, I will not be able to establish my life in India because I am not an Indian citizen. I mean,
Yes, that is.
we can't take that any further, but he doesn't say that.
Yeah, he hasn't said that. And
He talks about the social difficulties he's had because of the circumstances of his marriage to your client,
and
with the family difficulties that he says arose as a result of that, and the difficulties his business would have.
yes,
The difficulty I have with that paragraph, and it's a very short paragraph, which is where some of the difficulty comes from. It almost seems to be implicit in paragraph 9 that if the family approved, there wouldn't be any obstacle. He's not saying, quite apart from the fact that I can't go back, we've got a social problem. Do you see?
yes. That may well be a way of looking at it, but in my respectful submission, taking the statement together, and I go back to the wider context of being the length of residence. and his overall evidence that I wouldn't go back. Now I accept, and I'm not challenging Upper Tribunal Judge Gleeson's approach to family difficulties, which she says weren't evidence. I accept that was a finding which was open to to Judge Gleeson to make. But what I do reaffirm is the wider context here relating to the length of residence, which is, in my respectful submission, the bedrock of their individual family life and their family life together in the UK, and relevant also to the ability to now restart that elsewhere. That is a relevant assessment when looking at Article 8 and issues with difficulties with restarting one's life.
That forgive me for kicking, but I think we're quite close to the heart of the matter. That Judge Gleeson did deal with, didn't she? Because
74, isn't it?
I mean, once you accept that the social difficulties to which he refers are not accepted by Judge Gleeson and that you can't challenge that, we have to leave that on one side, don't we?
Yes, yes.
And is that why you said very fairly that the bedrock of your submission is essentially the length of time they've been here?
Yes, which is relevant to their ability to restart their life within India. And I think if I may, what is important here is this isn't strictly speaking an EX.1 insurmountable obstacles assessment. This is an outside of the rules assessment, and challenges with going back to India, either for the appellant or the couple together, is only an element of what is relevant to the overall Article 8 proportionality assessment. So you could quite well find a scenario where there are not insurmountable obstacles. There are general difficulties associated with length of residence, having a home in the UK, having a genuine business which has been trading since 2012, and that being a difficulty with restarting your life in India. But that is just one component.
Is the test for us insurmountable obstacles, or is the test for us unjustifiably harsh consequences?
In my respectful submission, judges, it's neither. And if
it's neither.
So neither in the sense that, strictly speaking, insurmountable obstacles is a test under EX.1. What say in the CHR recognises is that is still a relevant question when looking at Article 8 outside of the rules, and that is also what the sixth principle in GM Sri Lanka refers to. That anything which is and the term used in GM Sri Lanka is in fact reasonableness when looking at Article 8 outside of the rules, whether it's reasonable for the relationship to continue outside of the UK for whatever reason that may be, and that's irrespective of whether or not the issues are insurmountable or there's undue harshness. With respect, sometimes what appears to be, and may well be, the conflation with the undue harshness test is that is outside of the rules within the rules under Gen. Point 3.2, which again is not being argued. Issues with going back and difficulties, whether they characterise as insurmountable obstacles or undue harshness, can still be relevant, but they are a single factor within the proportionality assessment.
So if I've understood correctly, Mr. Raza, your answer to my Lord's question is that the test isn't insurmountable obstacles, it isn't unjustifiable harshness, it is simply a proportionality assessment.
Yes.
As to which you say two things. Number one, with respect to the judge, she didn't make one. Number two, insofar as she may have done, she didn't give appropriate weight or didn't visibly give appropriate weight to factors in the appellant's favour.
Yes.
and in part she based her decision in paragraph 74 on a misunderstanding that the husband is an Indian citizen, of which there was no evidence.
Yes, and what it appears is because Upper Tribunal Judge Gleeson finds that there weren't insurmountable obstacles, that appears to conclude the proportionality assessment. And in my respectful submission, that is that is in error. There is no weight given to the family life. Again, Section 117B4, Section 117B becomes relevant here because this isn't a relationship to which Section 117B4 applies, i.e. the little weight provisions. He married when the appellant was lawfully resident and her husband had ILR. The little weight provision doesn't apply. They were granted leave to remain on the basis of that relationship. So full weight had to be accorded to the family life because Section 117B4 didn't bite.
How do you say the proposed removal interferes with your client's right to restrict the family life?
They clearly do have a family life in the UK. The evidence from the appellant's husband, is recorded in the judgment as well as the statement where he says he won't go back. And there was I can give a reference to that. There was a question asked in cross-examination where he says he wouldn't return to India. So there is therefore severance of a relationship which has subsisted for many years in the United Kingdom entirely properly, not in precarious circumstances or unlawful circumstances, a relationship which has also been regularized by the grant of leave. I accept, again, of course, we can't ignore the deception point, which does become relevant. But that is the context. So there is that severance of that relationship.
But he doesn't. It's the evidence was the way it's put in his statement. It wasn't that it's insurmountable. He couldn't go back, but it would be very difficult for him to go back.
Yes, yes.
So it would be his choice not to go back.
Yes, but
because of the difficulties for his business and social life in his case.
Yes.
His case.
Yes.
So if it's his choice not to go back, to what extent is the proposed removal an interference?
In my respectful submission, I don't think it's proper to characterise it simply as choice when one has to look at the entire context here again, giving up a business, giving up where the appellant's place of residence since 1995, giving up the home which he's purchased in the UK, in my respectful submission, does not amalgamate to merely a choice as to whether or not he could go back. And again, that is what is addressed at the sixth point of GM Sri Lanka, which tells us that features like that are relevant when looking at the reasonableness, irrespective of whether or not it's an insurmountable.
Choice is not a binary.
Precisely.
It's not a binary question whether he's going because he's forced or because he chooses.
Yes.
Your submission is that we should look at the reasons why he makes that choice because they are relevant to a proportionality assessment.
Yes.
Okay.
Yes. And that is what the character of an articulated evaluation requires, and that is absent with respect from Upper Tribunal Judge Gleeson's decision. The other point, again, following on from that passage is perhaps they are of less relevance, but when looked at in the context of this not being a little weight or a no weight scenario under Section 117B4, what I do submit is also relevant is the fact that, for reasons which I don't have the answer to, what is established is the appellant did not need to rely on the ETS test certificate for her leave to remain to be granted. It was immaterial, and that is, in my respectful submission, apparent from the GSID notes, and that is also relevant.
It's not immaterial, surely. You may say it was unnecessary, but it's not immaterial because here choice comes into it as well.
Yes.
And she undoubtedly, her evidence is she did it at the suggestion of her solicitors.
Yes.
So they clearly didn't think it was immaterial because it was a cost involved of £250 and so on and so forth. What I think you're saying is that there was other evidence upon which the basis of which she could have been given leave.
And that evidence was in fact, perhaps to clarify the submission, the ETS test certificate was irrelevant for the purpose of meeting the English language
No,
requirement.
the highest you can put it is unnecessary, surely. Unnecessary.
It's strictly in the context of the ability to meet the rules. She had alternative evidence which was sufficient, which was before the Secretary of State.
But she chose to put in two pieces of evidence.
Yes.
I mean, had the ETS been legitimate, you could have said the same about the other certificate, that it was irrelevant. And I think I would still suggest to you that it's not irrelevant, even if it's unnecessary.
Irrelevant purely in the context that it wasn't needed to meet the rules. I accept.
Well, in that case, we understand each other.
Yes. I'm grateful.
Okay.
I'm just looking at how it was put before the Appellate Tribunal on behalf of your client. It wasn't by you, was it?
No.
Am I right that it's on page 56 of the submissions? Are these I may be in the wrong place. Mr. Raza, please correct me if I'm wrong. This is we're looking at the document prepared, I think, by your predecessor, Mr. Fripp.
Yes.
Am I right?
Yes.
For the hearing on the 6th of June.
Yes.
So it begins at page 40, concludes on 57. Am I right that paragraph 24 addresses Article 8?
Yes. Yes.
That's the section dealing with Article 8.
Yes. Yes.
And the way it's put there is, and this echoes something you stressed this morning, length of stay, length of time here, is how it's put really. Present since 2006, entirely lawful for much of the time, you say, or he said. Married since 2010, attempted to start a family here, supported by working here, removal will be unduly harsh after they've been married for 12 years. That's how it's put.
Yes. Yes.
Sorry, I'm just reading, and I'm afraid I'm slightly behind, my lord. But I notice also at the foot of the page 56, a further factor is added. They've suffered from the effects of the allegation hanging over the appellant continuously since February 2015.
Yes, which I have to perhaps concede does fall away somewhat when.
Given the circumstances,
Yes.
as to why it's been hanging.
Can we tidy up one other point which is bugging me?
Yes.
Because possibly an oversimple view is she has no one to blame for that, because for the delays and so on and so forth, because she has pursued right up to the upper tribunal the assertion found to be false that the ETS certificate was legitimate. But I suspect one of your answers, although I haven't quite teased it out yet, is that there were two things that kept this process going. And if you're right on Article 8, then, to go back to what I was saying before, the deception is at worst a concurrent cause of the delay, because the delay would have happened anyway, because the tribunals up till now have failed to see the strength of your Article 8 case.
That is correct, and we only get to Article 8 because the deception issue has been found in the appellant's favour.
Yes.
Against.
Yes, but it's always been there.
Yes. Yes. Now, what I would accept is that is, in my submission, also a relevant feature when looking at the proportionality assessment. In the sense that one of the arguments is that it has now been 10 years since the allegation was raised. some 13 years since the relationship has been subsisting. What would mitigate the strength of my argument is the appellant is clearly complicit in part of that, because she has challenged or resisted a relevant element. So I would accept that would mitigate or in favour of the respondent, in favour of removal. But at the same time, one of the points which I say again mitigate against that is the argument about the relevance and the need for the ETS test certificate in the first place. So what I say, what this basically brings us back to is the Article 8 proportionality assessment is a far more nuanced exercise, which with respect hasn't been conducted by the upper tribunal.
And if we were in favour on your main submission,
Yes.
what do we do? Do we remit to the UT to retry, or what?
I think that would be fair, and
Because we're not being asked to quash the 2015 decision. We're being asked to quash
yes,
the decision of the upper tribunal.
that is correct, and I think that would be fair. And what I would be seeking is a remittal to the upper tribunal with preserved findings on the ETS point.
Yeah.
Again, acknowledging, even though an argument was run under the suitability provisions, acknowledging the point by Lady Justice Andrews in the grant of permission, but the extent of the evaluation required it being a fair and complete proportionality assessment. Now, I think I could perhaps candidly accept these arguments are being developed more, and the focus clearly was before the upper tribunal on ETS. It does seem to me that is how the appeal ended up in 2022, with the focus or larger parts of the focus being on the ETS, and there has been some degree of oversight on either party or in respect of the Article 8 issue. That does become more of a worry when it was remitted by Upper Tribunal Jackson on the Article 8 issue, but I think that is apparent from the judgment that, and I also recognise by Lady Justice Andrews that there has...
I'm not suggesting we would go down this route, but would
Yes.
it be open to us,
Yes.
given the paucity of evidence to say, okay, this consideration was theoretically inadequate or technically inadequate, but had an adequate course been followed, the result would have been the same, therefore appeal dismissed.
In my respectful submission, this court cannot be satisfied that having had and conducted a full and proper proportionality assessment taking account of all factors, that the outcome would still be the same.
No, but if we didn't agree with that submission, then we would say appeal dismissed.
Yes.
Yeah.
Yes.
Okay, thank you.
Unless there's anything further I can assist my lordships with.
No, thank you very much. Thank you, Mr. Raza. Yes, Miss Pottle.
My lords, the issue in this appeal is a narrow one, and it is simply whether Upper Tribunal Judge Gleeson erred materially in her consideration of Article 8 outside the rules. In summary, my submissions on this narrow issue will be, firstly, that Upper Tribunal Judge Gleeson made as full an assessment as she could in the circumstances where the evidence was extremely limited. But in the alternative, as my lord has just canvassed with my learned friend, my submission would be that even if she did technically make an error in her assessment, that error was not material, given the evidence in this case. If it assists, my lord, I first propose to set out, and I'll take it quite shortly, some of the facts which I think are relevant to your determination.
Yep, by all means.
Yes, certainly, and then I'll deal briefly with the legal framework, and then I'll make some submissions. In terms of the facts. The first document I'd like to take the court to is at page 140 of the core bundle. And that is the explanatory statement, which was adduced by the respondent in the appeal proceedings. As with much of the material in this case, the statement is principally concerned with the deception issue, which doesn't concern this court. But if I could just draw the court's attention to a paragraph 4. There's an explanation, useful background as to why the appellant's leave was curtailed when she returned from India. And the appellant was stopped by a border force officer, and she had said that she was a student and had finished her studies in either 2011 or 2012, but couldn't be sure. She said that she had been married in 2012. We know
That's the wrong date.
That is the wrong date, yes. And she had used a TOEIC certificate in her application for her spouse visa. She said she had switched from a student visa to a spouse visa. In fact, it wasn't a visa. And the officer then noted that that certificate was one which had been marked as being fraudulently obtained. And therefore, he invited the appellant for a further interview.
But forgive me interrupting.
Yes.
In paragraph 4, Officer Melville noted. Does that mean he, as it were, internally noted, or he explained to the appellant? Seems a bit ambiguous.
Yes, I'm not sure actually whether he explained to the appellant at that stage.
No.
But certainly when she was invited for the interview, and the contents of the interview are summarised at paragraph 18, it's clear that the focus of that interview was on the language certificate and her private life in the UK, family life in the UK, pardon me.
We haven't got Appendix B.
No, it's not included in the bundle.
Paragraph 18 looks a fairly full account,
Yes,
and the correct marriage date is given.
yes, that's right. The appellant's immigration history is summarised at paragraph 16. That has been gone through in some detail by my learned friend. But what I would add is that in June of 2012, and I'm looking here about 2/3 of the way down the paragraph, the appellant had applied for leave to remain as a spouse, but that was refused in July because she failed to produce the required English certificate, and she wasn't exempt. And then she made a further application, which is the one with which we're concerned. At paragraph 24, the Article 8 claim outside of the rules is dealt with. I should say at this stage, the Secretary of State didn't have, of course, the statements which were adduced in the appeal. So didn't have sight of the appellant's evidence, which the upper tribunal judge had. But nevertheless, the considerations in paragraph 24 remain material to the assessment outside the rules. I won't read out the whole paragraph, but in dealing with the question of insurmountable obstacles, and I'm here about halfway down the paragraph, the officer says that the appellant's husband was born in India. His formative years were apparently spent there. According to his immigration history, he entered the UK as a clandestine illegal entrant on the 11th of February of 1995 and was served with notice as an illegal entrant on the 15th of February. He sought asylum, which was refused in December, and he thereafter remained in the UK with permission. After an aborted attempt to seek leave in 2004, he sought leave outside the rules in 2006. His application was still undecided some 3 years later, and he was encountered during an enforcement raid at the premises of his business, Ocean Glazing. He was found to be the joint owner and was placed on regular reporting restrictions. At that stage, his representatives proposed that he be given indefinite leave to remain as a result of his unlawful residence of 14 years, and he was eventually granted indefinite leave to remain on the 27th of May of 2010.
Would that be on the basis that it's socially desirable that he should have leave because he's running a business and he's giving employment to people and things like that? Or on what basis do you say,
Yes.
you've been illegally here for 14 years, please can I have leave to remain?
Yes, it does seem curious. My understanding is that it's simply on the basis of long residence, even if one doesn't have lawful leave at that stage.
Well, I think someone sitting behind you might not think that's the correct explanation. But does it matter? I mean, it's a nice sort of prejudicial thing to waft across our bows.
Well,
to say he was illegal and he established the business when he was illegal. But at the time we're concerned with, they were married at a time when they both had suitable leave to be here.
The reason I draw your Lord's attention to it is because it's relevant to the Article 8 assessment outside the rules. And as I'll take you through the authorities, that assessment is a wide-ranging one. And the court would be concerned with questions of whether the appellant and her family members would have had an expectation throughout the course of their relationship that they would be able to establish their lives in the UK. And though my Lord is correct, the appellant's husband did eventually naturalize as a UK citizen, but it's in my submission, it's plainly relevant that at the time that they met.
But all the time, well, when they met, but all the time that they were married, which surely is all that matters for this grant of leave, the only thing that made their expectations precarious was the fact that she'd relied upon a fraudulent test.
I'm not sure that we're only concerned in the broad Article 8 assessment outside the rules with the time that they're married. I'll take my Lord through the authorities.
Well, we are if you're talking about expectation of ability to remain.
In my submission, the whole period of their relationship falls for assessment. And when they met, he was illegal. An illegal
yes.
entrant.
Well, how does his history as an illegal entrant affect her right to respect for family life? At the point we have to consider it.
Yes. Well, if I can take my Lords to the chronology in my skeleton, it's at page 5 of my skeleton argument. So the chronology sets out.
I'm afraid my pages aren't numbered. I don't know why. What paragraph?
6.
The chronology actually, I think, is below paragraph
6.
6.
Okay. Right. That's 3. Even I can count 3. Okay. So.
So this just sets out a chronology of the applicant's immigration history together with her husband's. And you'll see that in 2008/2009, which are the dates that they say that they met, there's some discrepant evidence about that. But at that point, the appellant's husband was unlawfully in the UK, and her leave was limited because she was here on a working holiday visa. So at the stage that they established their relationship, neither one of them could have had an expectation to remain in the UK. Shortly thereafter, or perhaps around the same time, he was discovered in the course of the enforcement raid, and he made an application on the basis of long residence. And it was only in May 2010 that he received his ILR, so he would have had an expectation to be able to stay here, but she was still, at that stage, on a working holiday visa. They then got married. Her leave expired in September of that year. She made an application, but that was for leave to remain as a student. He wasn't naturalized at that stage. Again, that was limited leave to remain as a student. And then the appellant's husband made an application to naturalize in 2012. That was granted in November of that year. And so at that stage, his leave was certainly settled. She was still on a student visa, and then she applied to remain as a spouse in September. She applied in 2013, and that was granted.
Is this a precariousness point?
Well, I don't want to use the word precarious because there have been a lot of decisions about what the meaning of precarious is and how it affects the balancing exercise. What I'm seeking to establish is that when considering the overall, under the Article 8 assessment, the court is required to consider all relevant factors. And in my submission, the fact that for most of their relationship in the UK, they were, their leave was such that they couldn't have been confident that they would be able to remain in the UK.
Something a bit uncertain, short of precarious. Is that what you would put it?
No, I suppose I
mean, it isn't precarious. It isn't precarious in the technical sense, is it?
Well,
at the point when it was established, and at the points you've taken us through, it's only after she gets stopped, isn't it, that it becomes. I mean, maybe I'm wrong. Please correct me if I am.
No,
this is when she stopped coming back by Officer Melville. It becomes precarious.
It was precarious at the outset. It changed.
Before they were married. Forgive me.
Shouldn't mince my words. It was precarious at the outset.
Yes, but that's before they were married. I'm sorry.
Yes.
But it is. Am I right? It's before they were married.
No, because even when they were married, even at that stage, she had limited leave to remain, and he wasn't a British citizen yet.
Okay.
So even when they got married, they wouldn't have had any expectation of being able to stay in the UK. It changed when.
Is that what precarious means? Precarious means you're always precarious until you get a citizen, until you're a citizen, are you? Or is it what? I may be wrong, Ms. Pond. Please correct me. I thought precarious meant if you were here without unlawfully, if you're an overstay,
No.
or if you're illegal.
That's not the sense that I don't mean it in the sense that it's unlawful. What I mean, I'm trying to draw a distinction between somebody who has an expectation that they will be able to remain in the UK, so has indefinite leave to remain, let's say, or is on a path to indefinite leave to remain on a spousal visa, if I can put it that way. So it's not simply restricted to somebody who is here unlawfully. The question is what their expectation would have been about whether they could remain in the UK.
But if the argument is that all this history is, for that reason, going to be relevant to the proportionality assessment, do you accept it's also relevant that the Secretary of State knew all that when she granted, or he at the time granted, the husband citizenship? Doesn't that rather shift the horizons on expectations?
I'm not sure I follow.
Well, you're inviting the court to take into account as relevant to the proportionality assessment the various stages at which the relationship was precarious, strictly so-called, or of uncertain duration, or whatever circumlocution we might like to use. But do we not also have to take into account that all that history was known at the time the husband was granted citizenship?
Yes.
And if it wasn't a reason for not granting him citizenship then, what weight can it carry in the proportionality assessment? You are a British citizen, but mind you, there's a dodgy history there.
I'm not suggesting that he shouldn't have been granted citizenship. That's not my submission. But my submission is that when the court looks at the Article 8 balancing exercise, it has to take account of all relevant factors. The authorities are clear that the immigration status of the appellant and their family members is a relevant consideration.
Okay, so is this a fair representation of the position that their status here, either before or after they were married, was not secure until leave was given to the appellant as a spouse?
Yes.
Because by then, subject to the ETS issue, they're secure. So from 2012, 13.
Yes. Well, she applied it in 2013.
Yeah, March 2013.
Yes. And so
Okay,
for those.
so the point would be that when the decision was made to cancel, this was relatively new. It looks long in the tooth now,
Yes.
but that's because of the procedural morass that's sucked this case in for years.
Yes.
Is that a fair representation of what you're saying?
Yes. It's a 2-year period, in fact, after she
Yeah.
applies for the spousal visa, and between that point and when she returns from
But
India.
do we? Why have I got ringing in my head somewhere that the proportionality assessment should be carried out as at the time, by reference to the facts as at the time of the assessment? So for Judge Gleeson, she should have been doing the proportionality assessment as at the time of her judgment. Am I wrong about that?
I think we may be talking at cross purposes.
Maybe.
Yeah. I think that when looking at the assessment, just because there came a point when the footing was secure, I can put it that way, doesn't mean that the period which came before is irrelevant.
I accept for these purposes. I accept that. But I'm now asking a different question, because longevity matters in your submission. Should Judge Gleeson have carried out her proportionality assessment as at the date in 2015 when the decision was made to cancel leave, or as at the date of her judgment in 2022?
I think
There must be an answer to that.
yes, it's actually dealt with. I think in GM, Sri Lanka, in fact. But I think because we're considering Article 8 rights under the Convention, I think the right answer is that she must consider the facts as they are at that point.
At the time that she makes the
yes, because she needs to
Okay.
reach a decision which is compliant with, under Section 6 of the
Okay.
Human Rights Act.
But if you have second thoughts about that,
well, I think
would you let us know?
I would like to take instructions on it. I mean, that's
Well,
my
but
initial view.
then perhaps I can assist Ms. Bottle. I don't claim to speak with great authority on this, but what you have just said is certainly my understanding. And that is why, for example, one might quite commonly come across the situation where at the time of the hearing, there are children of the family who weren't born at the time the original decision was made. But obviously they can't just be ignored just because they hadn't been born at the time of the original decision. Here we don't have any children, but we do have somebody who's been unable to pursue her course of treatment for as part of a decade.
Yes.
Yeah.
Yes, I have an instructing solicitor behind me, so if I can, at the conclusion of my submission,
Yes.
just check with her.
I think at the moment your submission is meeting with approval, but I may be wrong.
Well, there is the respondent is a large organisation, and so I think, in fairness to the respondent, it's probably appropriate to allow not just my instructing solicitor, but those on the live stream to consider whether what I've said is correct.
Is there authority for the proposition you made earlier about the security of their status, short of precariousness, being a relevant factor in proportionality.
Yes, I can. Don't know whether I should move to the law now or whether it would be
Please,
better.
please don't let me disturb you more than I have done already. So
Well,
you just put a little asterisk, mental asterisk,
Yes.
to come back to that when you want to.
yes, I will.
And talking of coming back, Miss Pottle,
Yes.
I'm afraid you've been the ship of your submissions has been tossed by winds from all parts of the bench, so blown you thoroughly off course. So we apologise for that. But can I just take you back? We were looking at paragraph 24 of the explanatory statement on page 146. Could I just ask for your help, please, with the final sentence, as the appellant's husband has in the past, etc. Is that merely saying, well, he's shown himself to be a versatile sort of man who can find a way through difficulties by one means or another? Or is it saying that even if he had no lawful right to go back to India because he's not an Indian citizen, somehow or other he'll be able to find a way even if it's illegal?
Well, I haven't asked that specific question from those who instructed me. I mean, I would be very surprised if the decision was made on the expectation that
Well, I would be.
the husband would do something which was unlawful.
Yes. So should we read it just as saying, well, he's somebody who's shown himself capable of meeting adverse circumstances before, and no reason why he shouldn't do it again?
Yes, that he's an adaptable individual
Yes,
who has established a
Okay,
life for
thank
himself
you.
in the UK.
Right.
I was had then planned to take my lords to the evidence which was before Upper Tribunal Judge Gleeson. I know my learned friend was asked to take the court through that. I'll just deal with it very briefly. At page, well, I'll deal first with the appellant's statements concerning Article 8, and I can start at page 133 of the core bundle. Sorry, it begins in fact at 132. The appellant gives limited evidence about her Article 8 rights, that she and her husband are trying for a child, that she's begun IVF treatment, and at that point she was still receiving treatment.
Do you accept that the fact that she was trying to have IVF and was prevented from having a second course by the fact that her passport had been handed in is a relevant consideration in the proportionality assessment?
Firstly, whether we accept that that is the case. There's no evidence, and there was no evidence before Judge
No
Gleeson
written
that it wasn't.
evidence,
So
but there's no suggestion that the judge didn't accept that.
no, there's no.
And there's no particular reason to suggest it should not be accepted.
No.
So, if it is accepted as a matter of fact, is it relevant to the proportionality assessment?
Yes, I think the authorities are clear that when the court's considering proportionality assessment, it must consider a wide range of factors, and it certainly would include her fertility treatment.
Thank you.
And so that first statement, the first in time, the Article 8 evidence is limited specifically to the medical treatment. And then at page 126 of the bundle is the second statement from the appellant. It covers her marriage to Harjinder Singh, their experience of lockdown, how her immigration status had caused problems within the relationship. That they are continuing to undergo IVF treatment. Pardon me, I should also say in paragraph 7, the appellant says that she used to help her husband managing his business, but because of her immigration status, she could not do that anymore. And then after paragraph 10, the statement deals really with the deception issue. And then the final statement from the appellant begins at page 123 of the core bundle. It deals predominantly with the deception issue. In paragraph 6, the impact of the case on her mental health. And at paragraph 6, she says that she, at that stage, is no longer taking, that she's not taking any medication, but that she had taken tablets prescribed by her GP.
Paragraph which?
That's paragraph 6.
6, which starts, I emphasise. I'm on page 130. Am I in the right place?
Oh, no, page 124, pardon me.
Oh, you're still on the second statement.
This 124 is the first, pardon me, the third statement.
Yep, okay. Sorry, I thought you'd moved on. My mistake.
There's an update at paragraph 7 about the IVF treatment, that she's not able to continue it. And then very briefly at paragraph 9, she says that she has been in a genuine relationship with her husband, and that is accepted. He has his life here in the UK, and I don't want to leave him. The husband's statements, he also made 3 in support of the appellant's appeal, and if I can begin at page 138 of the bundle. This is his first statement in time. He says that he met the appellant in 2009, they formed a relationship and got married in 2010, and they are in a genuine and subsisting relationship. And he adopts his wife's statement. His second statement starts at page 136 of the bundle. Again, he says that, reiterates that he's married to the appellant. He has a diagnosis of colitis in 2018. Describes his wife as a key aspect of his life, and that he supports him. He describes the impact of her immigration status on their relationship and their IVF treatment. And then finally, at page 134, there's the final statement of the appellant's husband. Again, it's relatively brief. Confirms that they're married. He says that it was a love marriage and that he supports her financially, morally, and emotionally.
And that was accepted, wasn't it, by the UTJ? That it was a love marriage, that it was a genuine subsisting...
Certainly that it was a genuine subsisting relationship, yes. That's right. And there's the first mention here of whether the appellant could or would go back to India. He says at paragraph 9, I will not be able to establish my life in India as I have social ties in the UK. I have a business which is thriving and it will make it difficult for me to continue my business. And then he says, as my marriage was a love marriage, it was not approved by the relatives in India. And this will be the biggest social difficulty if my wife is refused any right to stay in the UK. And as my Lord has noted, nowhere is there a statement here, or indeed in the evidence heard by the upper tribunal judge, that the appellant's husband wouldn't be able to return to India because of immigration status problems. That's not claimed. He doesn't say in terms whether he retains Indian citizenship or not, but he doesn't claim that immigration control will be a reason why he can't go back to India.
If someone wanted to, that could presumably be checked. Is whether he has dual citizenship.
I don't know whether that is information which the respondent holds.
No, but it could be checked.
By the appellant, I suppose.
Certainly by the appellant.
Yes, I think I see what
I'm not suggesting it should be checked before lunchtime.
No. Yes, inquiries. If my Lord would find it helpful, I can set and train inquiries about that. But I doubt they'd be answered before lunchtime.
Well, speaking entirely for myself, I don't think it's either going to be obtainable, or if it obtained, would be determinative of our decision. But that's just...
Well, it strikes me, Ms. Pottle, that we're really concerned with the evidence which was before the judge. But there are perhaps two ways of looking at it. One way is to say, as you have rightly said, that his statements don't include anything specific on this topic. Another way of looking at it is that since it is submitted on behalf of the appellant, that there was really no proper analysis, no proper balancing assessment, then it might be thought the topic didn't really crop up. Because if anybody had been paying any close attention to this, it would surely have been resolved very easily, one way or the other, at the hearing. But I think in terms of inviting you to gather evidence now, I think there's a difficulty about that when we're really concerned with what was before the judge
Yes.
below.
Yes, I wouldn't seek to dissuade.
No.
My Lord from that course. That is what I proposed to draw the court's attention to in terms of the facts.
Thank you.
If I can just deal briefly with the judgment of Judge Gleeson before I turn to the law.
Starting at page 29.
Yes, page 29 of the court bundle. It's recorded at paragraph 15 of the judgment, of course, that the appellant had accepted that she could not bring herself within the rules, which was the reason, I think, that Lady Justice Andrews refused permission to the appellant on the ground that the decision under the rules was incorrect. The judge carefully recorded the appellant's evidence at paragraphs 25 of the judgment until 42. There, and I'm sure my learned from will correct me if I'm wrong, the judge dealt with in detail the statements such as they were concerning Article 8. There's nothing in my submission that she left out in her consideration here. It was clear that she paid careful attention in my submission to the evidence which was before her. At paragraph 37, the judge records the evidence which was given at the hearing. And And she notes that in answer to supplementary questions by her counsel, she said that her relationship was a love marriage and neither family accepted the relationship, so they had to marry in the UK. She says that she met Mr. Singh at a Sikh temple. They both attended in 2008 or 2009. She could speak correct English, but not slang. I pause here to make the submission that it is quite telling that it was only in response to supplementary questions that the appellant gave evidence about when she had met Mr. Singh. Not suggesting that she didn't meet him at that time, but the evidence in the witness statements before the judge in terms of Article 8 was so poor that basic matters about her relationship with her husband hadn't been covered. So the judge was really dealing with very limited evidence to base her assessment on.
Well, is that fair? What they concentrate on, the witness statements, is the time, the fact of their marriage and the time since their marriage, where it may not be, I'm sure it could have been more detailed, but there's the detail about it being genuine and subsisting, there's the detail about the impact about the IVF, there's information about whether or not her husband would go back to India and why not. Is it fair to say that there's as it were, just a blanket inadequacy of the evidence?
Well, in my submission, the kind of evidence that would be expected in an Article 8 case would be how the parties had met, their plans for their lives in the UK. For example, in this case, perhaps some evidence about at the beginning they didn't know that they would stay here, but maybe over time, when the appellant was naturalized, they decided, all that kind of detail about their expectations about their life in the UK, or she doesn't deal at all with going back to India, what her ties there are, what it would be like for them as a couple to return, why she needs to stay in England, her integration, what she's done in the UK in all that time. And all these factors which the court is required to consider under the Article 8 balancing exercise, there was very little evidence presented by the appellants. I'm straying now into my submissions on it, but
Okay.
I would say that there really was a dearth of evidence before. There is some discussion at paragraphs 38 to 42 about the test certificate and the deception issue. But I would draw the court's attention to paragraph 40, where the appellant said in the UK that she had intended to continue studying, but in business management, not medicine. And in the UK, she was not very well from the financial. Her parents could not afford to finance any study for her. And while she said, I would teach to get job, she had neither studied nor worked except in her husband's business. And we know that's for a limited period, as she says in her statement. The judge also records in detail Mr. Singh's evidence. And the evidence given orally is reported at paragraphs 49 to 51. He gives evidence for the first time in cross-examination about a phone call which he received saying that his marriage had taken place without family consent and that he would think before returning. The judge didn't accept that, and Lady Justice Andrews refused permission to the appellant to appeal that finding. And at paragraph 50, there's the evidence about whether Mr. Singh could return to India. The appellant and Mr. Singh were both Punjabi born and bred, and so they used Punjabi both at home and in his business dealings, which were mostly within the Asian community, his business was the sale of double glazing. He could not pursue his business there, as the construction of dwellings was wood, not PVC or aluminum as here. Previously, when in India, the husband had been studying and helping his father with agriculture. He had not worked independently there.
I think that must mean the construction of the window frames was wood. Nobody makes a house out of PVC.
Not that I'm aware of.
Or aluminum.
In this country.
Well, they probably do, actually, somewhere. But, it's the windows we're concerned.
I think it's the windows.
Yeah. Anyway, so there was a bit of evidence about whether he could continue his business in India. But again, nothing here about a problem with immigration status and returning. And it's clear that he had lived in India and that he had been helping his father with agriculture there. At paragraph 62, the judge deals with the NARIC certificate. I'm just going to spend a bit of time on this issue because my learned friend made the submission that the ETS certificate wasn't material. The evidence was that the appellant produced documentary evidence of her degree in India, which was completed in 2006. It was taught in English, and a letter dated the 13th of December 2012 from the NARIC agency, which is the National Recognition Information Center in the United Kingdom, states that the level of English in the above degree course does not meet the requirements of CEFR level C1. CEFR is the Common European Framework for the recognition of language. And the judge says here that the letter could not have been included in the appellant's application, which was submitted on the 7th of December of 2012. I pause here to say that though the letter postdates the date of the application, my learned friend is right that it was considered because the application was considered in March, and it's clear from the notes that this letter was before the Secretary of State when the decision was made. I don't accept my learned friend's submission that this letter would have been sufficient on its own for the appellant to meet the language requirements.
I didn't understand Mr. Raza to put forward that as a relevant point on Article 8. I may have misunderstood his submission, but he wasn't saying that she could have got it anyway, even if she'd not been fraudulent.
That was my.
But he was saying that. He wasn't saying that's an Article 8 point. I may be wrong.
Yes, my understanding of my learned friend's submission was that in terms of the proportionality exercise, because that is what he's limited to on the appeal, he's saying it is relevant that she fulfilled the requirements anyway, and so the fact that there was a fraudulent certificate is less important because she would have met the requirements of the rules in the event.
Yeah, but it's the fact of the.
I think that's a fair summation.
Yes.
You asked me to. My misunderstanding.
And so my submission is that it's certainly not clear that she would have met the requirements without the test certificate.
Well, there must be an answer to this.
Yeah.
And the upper tribunal judge did not accept that the UK letter would have been sufficient. There must be something. The letter of the 13th of December itself says the level of English language for the above degree course does not meet the requirements of CFR level C1. But then it goes on to say would involve proficiency of CEFR A1.
Yes.
Well, somewhere it must say whether CEFR A1 is sufficient to satisfy the requirements.
Yes,
And
well,
at the moment, I don't know where it says it.
so in the rules,
Are we in the
The language
authorities? Are we in the authorities bundle?
yes, we're in the authorities bundle. The English language requirement is at page 20 of the authorities bundle.
2-0.
Yes, 2-0.
Thank you.
We looked at this, didn't we, with Mr. Razak? We looked at it with Mr. Razak.
Yes.
Yeah.
So it begins on page 20 and then continues over the page 21. So the requirement is the applicant must provide specified evidence that, and in her case, B, have passed an English language test in speaking and listening at a minimum level of A1.
With the provider approved.
Yes, exactly. So that would be the ETS certificate.
So
That's
not,
a test.
there is no, not here because no provider, nothing from an approved provider.
Well, it's a fraudulently obtained certificate from the approved provider.
Hang on, I'm having a little bit of difficulty hearing it, which is my fault. It's my hearing. But two things. UK NARIC is obviously a well recognised. It's obviously sort of part of the system, although I didn't know that. So the one obvious point of distinction is it does not say she's passed an English language test. All it says is, as its medium, it's possible for us to confirm that she will have met the required proficiency expressed for CEFR A1. Is that the point?
Well, that is a point.
Well,
Not the one that I had thought of.
Well
It's a
done.
good one.
That's got one.
that's a good start. But at the moment, what I don't understand is how you marry page 21 of the authorities bundle to page 96 under the ATM letter
Yes.
and say, therefore, it's not good enough, or therefore it is good enough. And
Yes.
I'm sure it's my fault.
No, I haven't.
You haven't done that yet.
I haven't done it yet.
Okay.
So, point B is a test with an approved provider. It's not. The letter wouldn't satisfy the requirements of paragraph B. Paragraph C is where a letter from NARIC comes into play. Paragraph C says, have an academic qualification recognized by NARIC to be equivalent to the standard of a bachelor's or master's degree or PhD in the UK, which was taught in English. But this letter doesn't say that specifically. It deals with a related but separate issue, which is that the degree was taught in English and she would have this very basic capability.
Can you run that again? It's a bachelor's degree, so that's the first question. Academic qualification, bachelor's degree, which was taught in English, which it was.
Well, it says to be equivalent to the standard of a bachelor's degree in the UK, which was taught in English.
Okay, so is the point then that it's not demonstrated that the Bachelor of Science at the Punjabi University is the equivalent of a bachelor's degree in the UK?
Yes.
Well, what's the answer?
I imagine.
I don't know. There must be something somewhere which says a Bachelor of Science degree at the Punjabi University is not recognised as being equivalent to the standard of a bachelor's degree in the UK.
Yes.
Well, where
Considering the evidence that was before the judge, or in this case, that was before the Secretary of State, it was for the appellant to submit the evidence to show that she met either one of those criteria, so either the test or a letter which explained that the degrees were equivalent. And the letter on its own, in my submission, wouldn't meet the requirements. And as my lord put it to my learned friend, she would have provided both documents on advice. She was represented. And it's clear that the Secretary of State considered the letter together with the certificate.
certainly.
And so I don't think that my learned friend can make with the submission that the letter would have been enough on its own. I mean, we simply don't know. It wasn't considered on its own. And from the terms of the rules and the terms of the letter, I think it would be an assumption that the court shouldn't make, that it would be enough on its own.
So, I mean, your focus then is on the equivalence of the two degrees. rather than the teaching in English. The NARIC letter, just to make confusion worse confounded, says, as I understand it, it is taught in English. Can't say that the standard of English would reach level C1, but it does meet level A1. And that's fine, except that nobody tells us whether A1 is sufficient or A1 is not sufficient, but C1 is.
Well, it's sufficient if you pass an English language test with a provider approved by the Secretary of State.
Yes.
That's
Yeah.
under B.
Yeah.
And so, basically, I don't mean this in a pejorative sense. You're sitting on the burden of proof, and you're saying it's for the appellant to demonstrate, and it's not demonstrated that she comes within either B or C.
No, the submission I'm trying to make is that the appellant's submission is that the test was immaterial because she would have met the requirements
Correct.
just with a letter.
Correct. And
my submission is the court can't be certain that that's true.
because the burden is on the appellant to demonstrate compliance with B or C, and for the reasons you've given, compliance has not been demonstrated.
Yes.
And that would give a logical reason why the solicitors said you must go and do an ETS test.
Yes.
If there was at least a lack of certainty about the sufficiency of the UK, what's it, test? NARIC. Thank you.
What's your submission? Do you have a submission if you're wrong about that? In other words, if Mr. Raza is right in saying there was a sufficient equivalent qualification, what is your submission about the impact of that on the Article 8 issue?
The Article 8 assessment, I'm starting to feel like a broken record here, but is and it's because I haven't taken my lords through the authorities yet, but it's a broad assessment.
Yes.
The fact that she would have met the requirements would be relevant, but the fact that she used deception, also relevant, the length of time in the UK, I mean, there's a plethora of factors, and so I'm certainly not, and I hope I haven't given the impression that this issue would be material to the outcome. It's just one of the factors to be considered.
Well, it wouldn't be determinative to the outcome, but you're accepting that it could be material to the outcome. It could be something to be brought into account in a
Yes.
proportionality.
Yes, pardon me, I was imprecise. It's relevant,
But not
it wouldn't be
decisive.
determinative.
Not determinative.
Yeah. Thank you.
Okay.
You were still in the judgment, weren't you? We hadn't finished. I don't think we finished.
Yes.
You finished.
Yes, thank you. I'm grateful, my lord. Then, so that deals with paragraph 62 of the judgment, and then at paragraphs 72 and onwards, or in fact, it's really 73 and 74, which my learned friend's already taken you to. The upper tribunal judge then comes to her conclusions on Article 8. I know my lords have the point that she held that there was no evidence of the family disapproval relied upon, and the appellant's been refused permission against that finding. And the conclusions, I would submit, they are succinctly put, but they encompass her detailed examination, which preceded those paragraphs.
Do you submit?
I'm sorry. I'm sorry for talking across you, but I'm bound to say, speaking for myself, Miss Pottle, I do just wonder about that last point, because as you've helpfully noted, that the judge at paragraphs 25 onwards sets out the appellant's evidence. Paragraph 42 is really about the fraudulent test, but 25 to 41 is, broadly speaking, other matters. There's then the summary of the husband's evidence, 43 to 51, largely to do with the fraudulent test, but not exclusively. And I just wonder where in the judgment we see any of that being brought into any kind of balance. The judge rejects the suggestion that there's a problem of family disapproval. Well, fair enough. Then in 74, she observes that the appellant is not currently receiving treatment because the respondent has her passport on her account. Doesn't say whether that's a point of any relevance or whether it should carry any weight or does carry any weight. She says no significant obstacles to reintegration, but doesn't specifically address the evidence about that. And then refers to no insurmountable obstacles on what, speaking for myself, seems to be the false premise that they're both citizens of India.
Yes.
But there doesn't seem, unless you can take us to it, to be any kind of balancing of points for and points against. There's one point against the family disapproval point, but nothing to suggest there's a word to be said for them.
Well, in the judgment, which in my submission has to be taken as a whole, it's clear that the judge has in mind factors both for and against. So paragraph 50, for example, she notes here the evidence that they're both Punjab born and bred and that they used Punjabi at home and that his business dealings were with the Asian community and that he had, his evidence was that he couldn't pursue that business in India. I mean, these are all factors. Perhaps it would have been better had that paragraph been transposed into the conclusions part of the judgment. But if one considers the judgment as a whole in my submission, it's clear that the judge has the evidence such as it was in mind.
Right.
Where do we see the judge? And there's no balance, not a balance sheet.
No.
I think there's some suggestion, some of the authorities, a balance sheet would be helpful in this sort of situation.
Yeah.
We'll kind of come to that in a minute. no
Yes.
doubt. But if one was drawing up a balance sheet, the factor which Mr. Raza stressed is the length of time they've been here as the length of time they've been here, B, the time they've been as a couple. So those are factors in favour. Then there's his well-established business here, his income, which is supporting her, and then the disadvantages of going back. Now, some of those are addressed, but not all of them are addressed. Are there paragraphs, the last two paragraphs of the judgment?
The time that they've been in the UK isn't addressed in terms, but of course it's clear from her setting out of the evidence that she knows when the appellant arrived here, knows the date that they were married, and that there's no suggestion that they hadn't lived in the UK for that time.
Yeah.
But my lord is right, it's not specifically, expressly set out in a balance sheet type exercise. I have to accept that.
Nowhere does the judge say, for example, true it is they've been living here as a couple for many years, but that is outweighed by ...
That's correct.
Okay.
One has a feeling, perhaps I shouldn't say this, one has a feeling that the treatment of this, fairly peremptory treatment of this, the judgment reflected the way it was treated at the hearing. It was, and I mean, it's a minor factor in the documents, the statements, a minor factor in the submissions.
Yes.
Going through the judgments appear to feature much in the oral submissions, and it's a tailpiece of the analysis.
Yes, and the submissions that I will come to are that it was inherently so unlikely that this appellant would have succeeded on Article 8 outside the rules. That is, I mean, if I could be permitted to speculate, why the appellant's representatives herself didn't make.
All the more reason to set out the balance sheet or set out the balancing exercise.
Yes, but yes, I hear what my lord is saying. But it is really very difficult to succeed outside the rules. Extremely difficult. And so the central issue was deception, because no doubt the appellant's advisors would have told her that her best chance of success was to get herself within the rules, and that it was inherently quite unlikely that she would ever succeed outside the rules. But that's not to say that it wouldn't have been prudent to have a balance sheet exercise in the judgment, but that is the sort of background against which the case was conducted in my submission. I think now, after quite a lot of foreshadowing, I should take my lords to the
Yes,
to the authorities.
training your coat on this.
Yes.
The authorities. So,
I think I'll begin, in fact, with the authority of Aguiarco, which appears behind tab 4. Which is a judgment of the Supreme Court of 2017. The claimants in that case had unlawfully remained in the UK after the expiry of limited leave to remain, and each claimant formed a relationship with a British citizen. And their case on appeal was that the rules and the instructions, which, as it happens, are the rules and instructions which were in place at the time that this appellant's leave was revoked. Always a happy coincidence when that happens.
Often a tiny window to
Yes.
get through.
Quite a tiny window. In this case, the claimant's case was that the rules and instructions had led to a result which was incompatible with their Article 8 rights. Their appeals were dismissed, and Lord Reid, who gave the lead judgment, held that the rules and instructions which were in place at the time were compatible with Article 8. That's not to say that every decision made under them would be, but that the rules and instructions themselves were. Much of the judgment is focused on whether the claimants could come within the rules, within the exception, which we're not concerned with. But Lord Reid also deals with the exceptional circumstances requirement. And if I can begin by taking my lords to paragraph 46 of his judgment. And here he sets out his conclusions on the compatibility of the rules and instructions with Article 8. He says, it is important to appreciate that the rules are not simply the product of legal analysis. They're
Where are
not. 46. This is page 158 of the author.
line 3.
Thank you.
First line of 46.
They are not intended to be a summary of the Strasbourg case law in Article 8. They are statements of practice to be followed, which are approved by Parliament and are based on the Secretary of State's policy as to how individual rights under Article 8 should be balanced against the competing public interest. They are designed to operate on the basis that decisions taken in accordance with them are compatible with Article 8 in all but exceptional cases. And the Secretary of State is in principle entitled to have a policy of the kind which underpins the rules, while the European Court has provided guidance as to the factors which should be taken into account. It has acknowledged that the weight to be attached to the competing considerations falls within the margin of appreciation of national authorities, subject to European supervision. The margin of appreciation is not unlimited, but is nevertheless real and important. Immigration control is an intensely political issue on which differing views are held within the contracting states, and as between those states. The European Court the Convention has to be applied in a manner which is capable of accommodating different approaches within limits. Under the constitutional arrangements existing within the UK, the courts can review the compatibility of decision-making in relation to immigration with the Convention rights, but the authorities responsible for determining policy in relation to immigration within the limits of the national margin of appreciation are the Secretary of State and Parliament. And what I wish to emphasize is that the rules in this case, which I'll take you to in a moment, which the appellant doesn't meet, the instructions, which are the level sort of underneath the rules, also include guidance on how cases outside the rules ought to be approached. And my learned friend made the submission earlier this morning that the court doesn't need to apply an unduly harsh or exceptional circumstances test, and invited the court, if I understood the submission correctly, to conduct a more sort of freewheeling Article 8 assessment. And in my submission, per Lord Reed's judgment and Aguirre, it's clear that the court must consider the rules and the instructions, and that the Secretary of State is entitled to set within limits the way the Article 8 proportionality assessment should be carried out.
So is the key sentence in paragraph 46, about 7 lines down in that paragraph, that the rules are designed to operate on the basis that decisions taken in accordance with them are compatible with Article 8 in all but exceptional cases? So is the converse of that if you can't meet the rules, then it will only be in an exceptional case that you can succeed outside the rules?
Yes, and the exceptional circumstances are outside the rules are dealt with in the instructions. So there's also policy underpinning that consideration outside the rules, which I'll take my notes to in a moment. Lord Reed's judgment also deals with
There's a passage on precariousness. Is that relevant at all?
I wasn't planning to take my lord to it, but
Okay.
we have, in fact, so the paragraph on precariousness is also deals with the case of jeunesse, which we also
We're coming on to jeunesse. Jeunesse is later on in the bundle, I saw.
Yes, it is later on in the bundle. Paragraph 57 of the judgment.
5-7.
Yes, pardon me. Before I do that, and I apologize for jumping around, there was one earlier part of the judgment I wish to draw the court's attention to. Page 159, just above the heading of precariousness. Lord Reed reaches his conclusions on whether the rules and the instructions are compatible with Article 8, and he concludes that the rules and instructions are compatible with Article 8. It's at paragraph C on page 159. at paragraph 57, Lord Reid is considering the exceptional circumstances requirement outside the rules, and he gives some guidance as to how the proportionality exercise should be carried out. Ultimately, the court has to decide whether the refusal is proportionate in the particular case before it, balancing the strengths of the public interest in the removal of the person in question against the impact on private and family life. In doing so, it should give appropriate weight to the Secretary of State's policy expressed in the rules and instructions, that the public interest in immigration control can be outweighed, in this case, exceptional circumstances as defined. And it must also consider all factors relevant to the specific case in question. In general,
So that's the approach
yes.
which Judge Gleeson was applying. Should have been applying.
I think at this stage now, I don't want to jump around, but I think it's probably best now if I do take the court to the instructions, now that we know how they are to be considered, their importance. The instructions appear behind tab 3 of the bundle, and the relevant section on consideration outside the rules are at page 96 of the bundle. Where the applicant does not meet the requirements under Appendix FM, the decision maker must go on to consider whether there are exceptional circumstances which warrant a grant of leave outside the rules. And the decision maker must consider all relevant factors raised by the applicant. And there's further guidance on what is meant by exceptional circumstances. Exceptional does not mean unusual or unique. While all cases are to some extent unique, those unique factors do not generally render them exceptional. And the case is not exceptional just because the criteria set out in the exception of Appendix FM have been missed by a small margin. Instead, exceptional means circumstances in which refusal would result in unjustifiably harsh consequences. And this is the phrase used by
Where
my
I was
lord
coming
earlier.
from.
Yes, and so my lord was quite right. That is the test that the court should be applying. It is looking at unjustifiably harsh
But it is the test that you apply while carrying out a proportionality assessment.
Yes.
It's the last question at the end of a proportionality assessment is, would this have unjustifiably harsh consequences? So to that extent, the dice is loaded. It's not just, do I think it's a nice idea or not? It's
Yes, exactly. Because of the constitutional arrangements in the UK, this is the Secretary of State's policy. And as explained by Lord Reid and Aguirre, the Secretary of State is entitled to set that policy. And so this endpoint, as my lord put it, of unjustifiably harsh consequences is something that the court has to apply. It can't just decide whether it's a good idea or not, using my lord's phrase.
And then the instructions go on to consider how the court should approach exception, the analysis of whether the circumstances are exceptional.
Yes, it sets out examples of relevant factors, but again, they're not exhaustive.
Well, I note that the word all is in bold, all relevant factors.
Yes. Yes. And so the examples that are given that are relevant to this case, there aren't any children, but the immigration status of the applicant and their family members. So the decision maker should take into account the circumstances around the applicant's entry to the UK and the proportion of the time they have been in the UK legally as opposed to illegally. did they form their relationship with a partner at a time when they were in the UK unlawfully? Family life formed in the knowledge that their stay here is unlawful should be given less weight than family life formed by a person lawfully present in the UK.
So, if we go back to your earlier submission about not precarious, we were having the debate about precarious.
Yes.
How does that fit in here?
Well,
Or
firstly,
does it not fit in here? Is it something else? Carry on in a minute.
no. Well, firstly, the appellant was never in the UK unlawfully. That's accepted. But this is an example of a relevant consideration. And in my submission, in this case, a relevant factor is that when they met, the appellant's husband was unlawfully in the UK, and that will have informed their expectation of whether they could settle in the UK.
Right.
But,
So the period between 2008, whenever they met at the temple, and 2010, when he got his status sorted.
yes, although her status at that stage was still as a student.
Yes,
So it's
it
got
wasn't
gradations.
It wasn't unlawful.
No, it was never unlawful.
Okay. All right. So basically, your submission is it's a spectrum of factors.
Yes.
Lawfulness is at one end. Total indefinitely to remain is at the other end, and anything in between is relevant
Yes.
to a greater or lesser extent, depending on the circumstances.
Yes. Yes. Thank
Right.
you, my lord. Putting it much better than I did. But
I think I'd put it rather waffly, actually. I think you put it much better.
Um,
And then the next factor, nationality, and it's said to be a matter of particular importance.
yes, I mean, I read that paragraph as directed more towards children who have, British nationality and would be required to live in another country. That's not the case here. We don't have evidence about whether the appellant's husband
Okay.
has Indian nationality. But
So
we
the
know
particular importance is the child. So that point is about a child, not about an adult, isn't it? But it's still the immigration, the nationality of the adults is also important, isn't it?
Yes.
The difficulty I have about the husband's nationality is there's no evidence that he's Indian national. And I think it's accepted on all sides that the sort of starting point, although there is an exception, is that people are not to have dual British or dual Indian and other nation nationality. So if that's right, and if one assumes that having or not having Indian citizenship would have significant consequences about the ability to work, the ability to stay, the ability to set up his business lawfully, haven't you got a problem with the statement that they're both Indian nationals? Because you can't say it's immaterial. Even if you allow paragraph 73 and 74 constitute an acceptable balancing exercise, there's a material error in the middle of it. What do we do about that?
Well, Lady Justice Andrews, when she granted permission, noted.
Well, but we're not bound by that observation.
Well,
it's not a limitation on the leave.
But you can make it your submission.
I mean, I would invite you to.
But I'm not gonna let you get away with that quite so easily, because I'm going to ask you on what basis you make that submission. And you cannot answer to me, go and ask Lady Justice Andrews, because I can't.
No. Well, I would say that there's an error in the sense that there wasn't evidence before her that he was an Indian national. That's correct. She does note earlier in the judgment that he's British. And so she has in mind what is relevant to this balancing exercise, that he's British, and if he was to stay with his wife, would have to leave Britain. So she's got that in mind. The question of whether he would have to set up his business unlawfully in India, which my lord has in mind. He didn't give any evidence that he would have And so I don't think that Upper Tribunal Judge Gleeson was wrong in failing to consider that he might, have to be an illegal migrant in India, because he didn't make that submission. So she was wrong to assume that he was Indian because there wasn't evidence about that. But where that hangs in the balancing exercise, I don't think it would have made a big difference. The biggest difference it could have made is if he wouldn't be allowed to enter India, obviously, because then there would be a permanent separation between the two. He never made that point in his evidence before the tribunal, and so she was entitled not to consider that.
Thank you. Then we come to the next bullet point, which I think is Mr. Raz's, what he says is the strongest point. I mean, he'll forgive me if I'm overemphasizing it, but the time they've been here, and he hasn't put it like this, but it could be said to be the degree of integration, borrowing a phrase from habitual residents, the degree of integration that they've got in this country, particularly if we're taking the date as being the date of Judge Gleeson's decision. And the business that he set up with its PVC and metal windows, and so that's a factor. And where do we see Judge taking that into account?
Well, it's certainly a factor, but I would say that the evidence of the appellant's integration was extremely limited, because she had come to the UK, but her evidence at the hearing was that her parents couldn't support her in her studies. She didn't work except for her husband's business, and that was for a limited period because of her immigration status. So there wasn't much evidence that she had, in fact, normal sort of private life evidence.
But the bullet point is applicant and members of the family. So you look at them as a couple, or separately, and as a couple. And as a couple, Mr. Raza says that they were settled. They'd been married for, I don't know what it was now, 10 years. 10 years? 12 years. 12 years by the time of the Judge Gleeson hearing. The point about his work, dependent upon him, there's limited evidence about that, and limited reference to it in the judgment.
Yes.
So it is, you've accepted it's a factor. Where do we see the judge analysing that in the judgment?
Well, she does consider, I think it's paragraph 50, whether he'll be able to continue that business, because his evidence was about the dwellings being made from wood, not from PVC. So she does give some consideration to whether he'll be able to continue doing that if he returns to India. But it's not in a balance sheet.
What she says there is, he couldn't. This is the evidence, of course, isn't it? It's not. He's just reciting his evidence. He doesn't analyse it. Yeah. He says I think that's right.
Yep.
He could not pursue his business there for the reasons he gave. We don't see her rejecting that evidence. She doesn't comment on it, I think.
I mean, my reading of the judgment, taken as a whole, is that she considers that evidence. It's plain that she has it in mind. But it isn't. My lord is quite right. It's not set out explicitly in the analysis section of the judgment. But I think, my lords have my submission on it. But it's plain that she had it in mind. If we take the judgment as a whole, it was something that she considered.
Thank you.
The other bullet point which I wanted to draw the court's attention to is on page 98. And that's whether there are any factors which might increase the public interest in removal. And for example, where the applicant has failed to meet the suitability requirements because of deception issues. It's plainly relevant here.
But where does the judge take that into account as part of the balancing exercise?
Yes. This submission is primarily directed towards, my lord will recall, my primary submission is that the judge did make an assessment which was sufficient with the evidence that she had. But if the court doesn't accept that, my submission is that any error, it wasn't material because of the circumstances in this case. The appellant could not have succeeded. And in analyzing, in considering that submission, the court will have to look at all the factors, whether I'm right about that. And the court can consider here this bullet point about the public interest in maintaining immigration control and the interest in not allowing the appellant to remain in the UK where she has used deception in her application to remain here. It's undoubtedly relevant to the Article 8 balancing exercise.
If we have to exercise the discretion ourselves.
Yes.
Are you
Well,
going
I'm not asking the court to exercise
not discretion, wrong phrase.
Yes, but whether the errors are material, because, and my learned friend accepted, that if the court concludes that any mistakes made by the upper tribunal judge weren't material to the outcome.
I misspoke. It's not our discretion. It's the way you put it. Are you going to cite any cases which show how we should approach that if we get to that stage?
No.
In particular, how we should, how a court would be expected to balance this factor.
No, I hadn't. There are no authorities in the bundle dealing specifically with how deception is to be balanced. I think it's a bit difficult because, of course, there wouldn't be any guidance on. The guidance doesn't really deal with facts. It's for the court to assess in the particular circumstances how important it is or isn't. I don't think there's any dispute that it's relevant, but it's the question of whether it tips the scales or not will always be a fact-specific question. But I thought, in fact, what my lord was asking was whether there were any authorities dealing with the question of how you decide whether the error is material. There actually aren't, but I noticed we're almost at 1 o'clock. If it would be of assistance, after the lunch adjournment, I'll consult with my learned friend, but there's no real issue in law about that. I can draw my lord's attention to the authorities on the question of materiality, if that would help.
Well, does it come to this, that if on a proper assessment of all relevant factors there could only be one answer?
Yes, that's right.
Then any incidental error along the way by the judge won't avail the appellant.
Yes.
But if there was an issue which might have been decided one way or might have been decided the other, then the position is rather different.
Yes, that's correct.
And on that, although she clearly didn't believe the appellant about the document, we can't just translate that across and assume that she would have disbelieved her on all or any of the rest of her evidence.
No, I'm not asking you to disbelieve.
Just stating the obvious as it comes.
Yeah, no.
Well, just thinking about overall timing, Ms. Pottle, are you subject to anything you want to check? And you did want to check to make sure that you were right in saying the judge had to assess Article 8 as at the date of the hearing before her. But subject to checking matters, have you reached or nearly reached the end of your submissions? And I'm not saying that critically. I'm
No,
just
no.
thinking about timetable.
No, in fact, what I planned was to finish. I had two other authorities, and then I was going to begin my submissions. But I've actually made most of them
Well,
in response to questions.
Mid and arguendo.
There
as
may
we
be
used
some
to say.
pruning.
Okay.
Can I just ask, are you going to say anything about GM?
Yes, I was going to take the court to GM, but if my lord has any specific questions that I could
No.
ponder over the adjournment, I'd be.
No, I was.
All right. Well, obviously you need some time to finish, and then Mr. Arson will perhaps want to reply on some points. So shall we? Is it convenient to break off there? I'm very conscious we've done almost nothing but interrupt you ever since you stood up, which I know is very vexing for the advocates. But thank you for your patience. And shall we resume at 2 o'clock?
Yes.
Thank you very much.
Right.